Please, Lordship. Lordship, I beg to mention this item number 4, Lordship. Item number 4. So this matter can come up after 1 week, Lordship.
Why?
After 1 week.
Why?
For the petitioner, Lordship. Lordship, the senior counsel has some difficulty, Lordship, in the other court today, Lordship. Some hearing is there, Lordship. So I'm praying for 1 week's accommodation, Lordship.
You are for
the state, Your Lordship.
who's for the school?
The school is...
But have you informed the other side?
Lordship, I'm not informed, Lordship.
You should have. You may have.
Lordship, I'll inform them, Lordship.
On premier petitioner seeking accommodation on grounds of personal difficulty of the learned counsel, learned senior counsel. What is adjourned? When is this thing after?
1 week,
1
Lordship.
week.
Duly, Your Lordship.
I beg to mention item number 2, my lord. After 3 weeks, my lord.
Because the Paul is in the bereavement.
All is in bereavement, my lord.
Mention is made on behalf of the learned senior counsel, Mr. K. Paul, who is said to be in bereavement and could not appear for the court today. On accommodation so sought, the same not being objected to by the respondent, that is adjourned. Why 3 weeks?
After 3 weeks, my lord.
Place this matter after 3 weeks.
Please, Your Lordship. Item number 5 and 6 of the hearing list, I'm praying for orders for closure of these matters, my lord. Item number 6 has become infructuous because the contesting respondent has expired. So that matter may be closed. As far as item number 5 is concerned, that's an election matter. I'm praying for some liberty that I withdraw this matter here and approach the election tribunal under the rules. Actually, what's happened is under the rules, there is a period of 30 days prescribed.
Then in that case, let it come up.
Yes,
Why
ma'am.
why
Yes,
make
yes,
them-
yes.
See, mention is made only for adjournment,
Right, Lordship.
not for
All right.
closure.
All right.
On daily list, item number 1.
Yes.
My lord. My lord, this is an bail application we have filed in respect of Bajingdoba PS case number 14-5 of 2023, Lordship.
Yes, Mr. Khera.
Lordship.
Why would I hear you? You have come before the court not properly attired.
Lordship.
Should show.
Sorry, Lordship. May I?
Yes.
Lordship. Lordship, I filed this bail application in respect of Bajingdoba PS case number 14-5 of 2024, registered under section 379, 403, 408, 409, 421 and section 7 of the Essential Commodities Act, Lordship. Lordship, the genesis of this case is that the FIR was filed and registered on 16/5/2024, Lordship, page 39, Annexure 3. Consequent to this, Lordship, I was issued a notice under 41A of the CRPC. Lordship, Annexure 4, page 43.
When was it registered?
On 16/5/2024.
Okay, 65.
Lordship. Lordship, dates would be a little important here in this matter. Consequent to the registration on 16/5/2024, On 22/5/2024, I was issued with a notice under section 41A for appearance. Lordship, annexure 4, page 43.
Yes.
Lordship, requiring me to appear on 27th of May 2024, which I did, Lordship, and I continue to abide by.
First, lead us to the FIR.
Lordship, annexure 3, page 39. If I may, Lordship,
This is
page 41 is the body of the FIR.
this is the
May I,
page
Lordship?
41.
Page 41.
Yes.
To the officer in charge, Bajingdoba Police Station, Bajingdoba, North Garo Hills, Meghalaya, subject first information report. Sir, with reference to the subject, I crave leave to state that I hold dealership of PDF under FSA as wholesaler for Resubelpara Center, Mendipathar Center, Dainadubi Center and Gokulgre Center. My wholesale unit is managed by my appointed manager Shri Pankaj Gupta @Pintu, son of Shri Hare Krishna Gupta, a resident of Anandmat Tura, District West Garo Hills, Meghalaya, since the month of August 2022. All of the affairs of my supply business is managed by my said manager, which includes lifting of stocks and distribution to various retail units. Of late, after having scrutinized my accounts and records from both my office and the concerned department, I found that my said manager, without my knowledge, had siphoned huge quantity of PDS rice issued under allotment for the month of December 2022 by way of lifting the stocks and selling the same in the open market at market price, thereby depriving the genuine villagers from getting their respective quota for the stated month. The quantity of PDS rice so lifted by him under regular allotment is described as under. Lordship, given the table, go on. In lemine, my said manager has lifted supplies under PMGKAY allotment for the month of December 2022 and the said food grains never reached the beneficiaries. The details under PMGKAY lifting includes as under. Furthermore, my said manager had lifted supplies under MDM allotment for the months and year indicated below and the said food grains never reached the beneficiaries, being school children. The details under MDM lifting are as includes as under. May continue, Lordship. Next page. Worthy to mention herein that I have been managing the short supplies for the stated period by adjusting the supplies with the buffer stock I maintained, which is otherwise supplied by the concerned authorities. However, at certain point of time, I am to make good the deficiency of 612162 quintals of rice, which is worth crores of rupees as per market value. The illegal action of Shri Pankaj Gupta @Pintu not merely becomes an offence of cheating under the various provisions of the Penal Code, but also under criminal breach of trust and under the provisions of Food Security Act as well. I further suspect that the food grain siphoned by Shri Pankaj Gupta has been illegally sold to various traders of the nearby market who have knowingly purchased the government stocks with malified intent of wrongful gain. Lastly, for past months, I have been trying to contact Shri Pankaj Gupta @Pintu in his mobile number so-and-so and so-and-so after ascertaining his scam, but to no avail. He remains absconding after knowing that all of his illegal actions have been found by me. I therefore humbly request you to kindly take necessary legal action against the said culprit as per law and thus obliged. Lordship, consequent to filing of this FIR, after a period of 1 week, Annexure 4, page 43, Lordship, a 41A notice was issued to me on the 22nd of May 2024, requiring me to appear before the concerned IO at 11 AM on 27th of May 2024, which I did. I had appeared, I was interrogated. I have denied my involvement in the alleged offence. Certain documents and materials were seized from my possession. Post that, Lordship, whenever I was called, I had been regularly appearing. I had been abiding by the conditions of the notice 41A of the notice given under section 41A of CRPC. Lordship, suddenly on the 14th of January at 5:30 in the morning, the police came and arrested me while I was abiding by the conditions of the notice under section 41A of the CRPC. It is on record that I have appeared before the IO concerned. Lordship, they came and apprehended me from my residence at Tura at 5:30 in the morning, dragged me and took me to Bajingdoba police station. Lordship, once I was taken to Bajingdoba police station, by afternoon they had taken me to the hospital for a medical. Lordship, Annexure 7, page 48.
When were you arrested?
On 14th of January 2025, Lordship. After a period of 8 months, while during that period I was abiding by the conditions of Section 41A notice.
Okay.
Lordship, at the typed copy is at page 49, Lordship. The matter of concern would be at page 50. The last enclosure, which is the opinion, Lordship. If I may read it, Lordship.
Yes.
In view of this, his recorded blood pressure, patient is newly diagnosed he's a severe case of hypertension and thus is not fit for a lockup. The medical opinion of the doctor, Lordship, says that I am not fit to be kept in lockup because of the severe condition that I am under. Lordship, page 51, Annexure 8.
Yes.
This is the remand order of the same day, Lordship. If I may, Lordship, para 5.
Yes.
The concerned judicial officer records it, Lordship, here. The latest medical report dated 14/1/2025, the medical report we have gone to, Lordship, states that he is not fit for a lockup, but considering that the case involves a serious crime and affects the economy and development of the country, this court has spoken to the doctor on the phone. The judicial officer, Lordship, goes and he speaks to the doctor over a phone call. And the doctor who had medically examined the accused person had informed the court that the accused Pankaj Gupta can be safely put in custody if he is medically examined daily. Hence, the court deems it fit that Pankaj Gupta be sent to custody. Lordship, after this, the medical report got changed. The doctor sends a new medical report. Annexure 9, page 53, Lordship. Lordship, what is interesting is the first medical report was generated at 3 p.m. where it was declared that he is medically unfit to be kept in custody. After the intervention of the concerned court, which is recorded in the order, where the concerned judicial officer speaks to the doctor, the medical report is changed and a new medical report is published at 7:50, available at page 53, Annexure 9, Lordship.
Yes.
The opinion, Lordship, at the bottom. Now, if I may, Lordship.
Yes.
At the time of examination, patient had no visible injury or any recent injuries or any sign or symptoms of recent illness on him. His blood pressure recorded, Lordship, this is also changed from the previous report, which was generated on the same day. As the newly diagnosed patient has severe case of hypertension, the patient can be kept in a lockup.
Yes.
The reason which the IO says that he arrested me is that I have not, when the 41A notice was served to me, the reason is that, Lordship, that I denied my involvement in the offence. So he says because I have denied my involvement of the offence, they have arrested me. Now, Lordship, if I may visit section 41A. Lordship, subsection 4 of section 41A.
Yes.
May I, Lordship? Subsection 4, Lordship.
Yes.
Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice. Lordship, there was no order. Had the concerned investigating officer appeared before that concerned court with a prayer to arrest me for reasons whatever might have been, I would have been given an opportunity to go and defend myself over there or to represent myself. Lordship, post this, a bail application was moved in the court of the judicial magistrate, same court who had called up the doctor with regards to the medical. Lordship, page 32, annexure 1. Para 6, Lordship. This court has come to the determination that, now these are the 4 grounds on which the bail had been rejected, Lordship, that the accused person is likely to abscond if released on bail as his ancestral home is outside the state of Meghalaya in and around Noida and Ghaziabad. Now, Lordship, ironically, the record which was present before the concerned court speaks that my permanent address is Anandmattura. My arrest memo reads that it is Anandmattura. I'll come to it, Lordship. The second ground, that his life may be in danger as there may be a possibility that the accused person Shri Pankaj Gupta may try to take his own life as he has constantly been informing this court of his mental health issues ever since the institution of the FIR of this case. Now, Lordship, I'm sorry, but then there is nothing on record which shows that I have said that I will commit suicide and I have mental health issues. And if so be the case that I would have said, then the duty of the concerned court should have been to send me for proper medical treatment. See, Lordship, the accused person has informed the court the previous day when he was remanded to judicial custody that he keeps sleeping pills at his local residence in Tura, West Garo Hills district, Meghalaya, and there is a possibility that, considering his own testimony with regards to his mental health, there is a possibility that the sleeping pills could be used deliberately as an overdose to take his own life. Lordship, where is that testimony? That since the instant case, there is a prima facie case involving so-and-so persons, and I will tamper with the evidence, Lordship. Lordship, the grounds, it is said that I am not from the state of Meghalaya and I am likely to abscond. When the record speaks, I am from the state of Meghalaya. The court goes on to say that I will take my own life as I have mental issues, and I have informed the court. The court goes on to say that I keep sleeping pills and so I will die of an overdose. Now, Lordship, where was this recorded? The first time I was ever produced before the concerned court was on the 14th of January when I was arrested and forwarded. Now, Lordship, I'll humbly request Lordship to come back to Annexure 8, page 51.
Yes.
Lordship, nowhere is it mentioned that I am taking sleeping pills. Nowhere is it mentioned that I will commit suicide. However, at page 52, para 11, at the second last line, Lordship, the court goes on to say that necessary steps be taken to ensure that he cannot overdose on medication or resort to any method to take his own life. Lordship, on 21st, after my police custody was over, the IO not requiring any further police custody, I was forwarded to the concerned court. The remand order of 21/1/2025, Annexure 11, page 57. The concerned portion is at page 58, para 12, Lordship. If I may, Lordship, para 12, page 58. All necessary care must be taken by the Superintendent of District Prison and Correction Home to also ensure that the mental health of the accused person does not deteriorate to the extent wherein their life may be in danger. So now the court is directing the jail authorities to ensure that I do not become a threat to them.
He is now in judicial custody.
He is in judicial custody for over a period of 1 month, Lordship. Despite,
What is his latest health report?
Lordship, he has a history of medical conditions and he is going on with those medical. He is a patient of severe hypertension, there is no doubt. Fluctuating high BP, and he's got other joint problems. We have attached the medical reports of those. But Lordship, I stand before your Lordship that when the law provided that once a notice under 41A was issued to me, I could not and I should not have been arrested without the prior permission of the court. When the concerned doctor who medically examined me declared me unfit to be kept in a lockup, I was still subjected to judicial custody, and consequent to it, the doctor generated a second medical report which was contrary to his initial observation. And I have denied that I have got nothing to do with this case. Lordship, all the sections charged are warrant triable sections, Lordship, by a judicial magistrate.
You mean to say they are bailable?
Lordship, they are not bailable. They are not bailable, but then it is a warrant triable section, and Lordship, warrant triable by a judicial magistrate, Lordship. Lordship.
Yes, Mr.
May it please your Lordship. Lordship, it appears from the FIR, your Lordship, that this kind of offence will come within the purview of economic offences, your Lordship. Lordship, there is an order passed by the learned session judge. If Lordship kindly come to page 36. Kindly see, your Lordship, the food, the essential items are meant for the poor people and as well as for the student, but these have been, Lordship, kindly come to page 36, the observation made by the learned session judge, your Lordship. May I read it, your Lordship? I have perused the case report from DIO dated so-and-so, case diary, and the material on record which reflect that huge quantity of rice under PDS and different scheme of the government worth crores of rupees meant for the genuine villagers, beneficiaries, including students, were misappropriated and sold illegally in the market, and the lawful beneficiaries were deprived of the right, and the accused person is named the FIR. It further reflects that alleged offence is of huge magnitude, in which many people seems to be involved in the alleged crime, and many witnesses are yet to be examined, and several documents needs to be procured, seized, and analyzed by the police through. Some documents have already been procured by the police. I also made a prayer for the recording of statement of the witness so-and-so under section so-and-so, and the statement of the said witness is yet to be recorded. Further, on perusal of the statement of the said witnesses recorded by the police, it appears that the accused person was involved in illegally supplying and misappropriating the rice under the public distribution system, and the statement of the said witness does incriminate the accused person. Kindly see, your Lordship, the learned session judge has gone through the case diary, your Lordship, and these are the material, your Lordship, that yes, he is the person, your Lordship, who has illegally sold the food items which are meant for the public as well as for the student in the open market, Lordship. It is a class, it is a grave offences, your Lordship, in my humble and respectful submission, your Lordship. To this, your Lordship, I would like to place a judgment, the observation made by the Honorable Supreme Court in this effect. Lordship, though this is in the context of filing of additional evidence, your Lordship, if Lordship kindly come to at page 371, your Lordship, the last page, your Lordship. Yes. Lordship, I'll read only the cause of the community.
Yes.
The cause of the community deserve equal treatment at the hands of the court in the discharge of its judicial function. The community or the state is not a persona non grata whose cause may be treated with disdain. The entire community is aggrieved if the economic offender who ruined the economy of the state are not brought to book. A murder may be committed in the heat of the moment upon passion being aroused, an economic offence is committed with cool calculation and deliberate design with an eye on personal profit regardless of the consequence of the community. A disregard for the interests of the community can be manifested only at the cost of forfeiting the trust and faith of the community in the system to administer justice in an even-handed manner without fear of criticism from the quarter which view white-collar crime with a permissive eye, unmindful of the damage done to the national economy and national interests. So can you see the observation of the Honorable Supreme Court in the matter of economic offence, Your Lordship? Another decision, Your Lordship, I would like to Lordship, kindly come to paragraph 24. At this juncture,
Yes.
it must be noted that even as per section so and so, Your Lordship is on, thus it is necessary to advert to the principle governing the grant of bail under section 439 of the CRPC. Specifically, heed must be paid to the stringent view taken by this court toward grant of bail with respect of economic offences. In this regard, it is pertinent to refer to the following observation of this court. In Jakan Mohan Reddy, economic offences constitute a class apart and need to be visited with a different approach in a matter of bail. The economic offences being deep-rooted conspiracies and involving huge loss of public funds need to be viewed seriously and considered as grave offences affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. So, Your Lordship, my humble and respectful submission, Your Lordship, in view of the finding of the learned session judge, Your Lordship, that huge quantity of the food item have been sold illegally, have been in the open market, Your Lordship, the petitioner, the bail applicant, Your Lordship, does not deserve the sympathy of bail, Your Lordship. Lordship, another contention has been raised that under section 41, he cannot be arrested without the warrant from the court, Your Lordship. That submission, in my humble and respectful submission, Your Lordship, is misplaced because section 41, Your Lordship, 3, subsection 3, Your Lordship, is very clear. Lordship, kindly come to that section. 41A, 3, Your Lordship. Lordship quoted.
Yes.
Where such person complies and continue to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice unless for recorded or for reason to be recorded, the police officer is of that he ought to be arrested. Your Lordship, in the case there, the investigating officer must have recorded the reason why he need the custodial interrogation of the accused, Your Lordship. That power is there, Your Lordship, to arrest. But only requirement is that reason has to be recorded if is required to be taken for custodial interrogation, Your Lordship. The IO must have done that, Your Lordship.
Where is that observation?
Lordship?
Where's the finding of the IO in this regard?
Lordship, that will have to only from the case diary, Your Lordship. That only from the case diary will reveal, Your Lordship. Lordship, so far here I have not come across, Your Lordship. But it will be reflected in the case diary. Why, Your Lordship, why a notice has been issued under section 41A, he complied to the notice, and all of a sudden he was arrested. There must be a reason. The IO must have recorded the reason, Your Lordship. Otherwise, Your Lordship,
Can you produce a CD?
Lordship, yes.
What is the stage of the case? Stage of the case?
No, Your Lordship, it's under investigation, Your
It is
Lordship.
under investigation. Lordship, the current IO who arrested me, he was endorsed the case on the 13th only. On 13th January, he has been endorsed with the case. He arrested me at 5:30 a.m. on 14th morning. So, for reasons to be recorded, the IO
When were you arrested? On
14th of January, Lordship. And this current IO, the case has been endorsed to him on the 13th of January.
Let me.
Anyway, what I think at this stage, as Mr. Shulai has submitted, this court would like to go through the opinion of the IO. If it fulfills the criteria as pointed out in subsection 3 and 4, then that's the end of the matter.
Lordship.
On that count, other aspect may be different, but let us satisfy ourselves first as far as why he was, in spite of being issued with the notice under section 41A, he was still arrested.
Lordship, had there been a reason, we should have been in the case diary, because the law
Exactly. So
prescribes the case diary to be forwarded to the concerned judicial magistrate when I am being remanded to custody to satisfy.
we'll look into that.
Lordship.
Heard Mr. Kira Leonard, counsel for the petitioner, who has submitted that this bail application is pressed in connection with a prayer made for enlargement on bail as regard the petitioner himself.
Lordship, petitioner himself.
Regard the petitioner herein, who was arrested in connection with Bajang Dova PS case number 14/5/2024 under section IT section. No? The Leonard Council has submitted that the FIR was filed as far back as July 2024.
May, Lordship.
May. What's the exact date?
16th May 2024.
16 May 2024.
15/5, Your Lordship, 24, the FIR.
Lordship, Annexure 3, that is the NCRB, National Crime Records Bureau's folio says.
1-2 days
The
doesn't.
signature of the Lordship.
1-2 days doesn't make any
Lordship, yes. No, it's just, yeah. 42.
Kununtu as far back as
Somewhere first.
16 May 2024. With the complaint that the petitioner, as manager of, you're a manager of what?
Lordship, I'm the manager of the complainant.
As the manager of the
Informant.
informant, complainant had embezzled or taken advantage of financial dealings to his personal advantage, thereby causing loss not only to the complainant but to the recipient of the scheme under the PDS inter alia for supply of rice etc. to the beneficiaries, as well as for supply of food materials required under the midday meal scheme.
Midday meal.
Thanks. Consequently, the investigating officer on investigation being launched had caused notice under section 41A CRPC to be issued on the petitioner. It is the submission of the Land Council that the petitioner has all along cooperated with the IO and has appeared before him from time to time. However, all of a sudden, on
8 months, Lordship.
8,
After 8 months.
no, when was the date he was arrested?
14/1/2025.
14/1/2025, he was arrested and is now in judicial custody. the contention of the learned counsel for the petitioner is that the IO had violated the provision of section 41A, violated the provision of subsection 4 of section 41A, inasmuch as there was no formal order of the concerned magistrate before the petitioner was arrested. The next contention is that in spite of the health condition of the petitioner, which was evident when he was medically examined by the medical officer, medical doctor, and a report being filed thereto, when at one point of time the concerned doctor has opined that he is not fit to be kept in the lockup. However, subsequently, the same evening itself, when the said report was filed, the opinion has changed. The medical opinion has changed to one of him, under bracket, petitioner being fit to be kept in the lockup. This contradictory stand taken by the concerned authority has impacted the mental and health condition of the petitioner, for which, under such circumstances, he may be enlarged on bail. Per contra, Mr. Endishwai Larat AJ has strongly opposed the primate. Firstly, on the ground that the allegation made in the said FIR, according to the prosecution, would constitute economic offences, and such offences, particularly directed at the community, are very serious in nature. In this regard, the Learned Counsel had Learned AG has referred to the case of State of Gujarat versus Mohanlal Jita Malji Porwar, 1987, 2 SEC 364 para 5, and also the case of Serious Fraud Investigation Office versus Nitin Johari and 2019 9 SEC 165 at para 24. Para 24 or para 24? 24. Wherein the Supreme Court had cautioned the trial court, the competent court taking up bail matters, to be strict in this regard, since economic offense would affect the community or society at large. The Learned AG has, however, the Learned AG in counter to the contention that no opinion was sought for, no order was sought for from the concerned magistrate by the IO in terms of section 41A(4), Kunung the sentence. Has submitted that the IO most probably must have noted down his opinion in terms of subsection 3 of section 41A to cause arrest of the petitioner. However, at this point of time, there are no records to indicate to find out the same. It is the submission of the learned AG that the case diary may be called for to allow the prosecution to place such opinion before this court as far as this aspect of the matter is concerned. In consideration of the submission made, this court is in agreement with the submission made by the learned AAG and would hereby call for the case diary, particularly with regard to specific indication as far as the opinion or finding of the IO is concerned, as to what caused him to arrest the petitioner. The prosecution is directed to comply with the direction is directed to comply with this order and to produce the case diary, copy of the case diary.
20, Your Lordship.
27.
27, Lordship.
Untuk
Obla, Your Lordship.
Hello,
just more. Next, it is Shuai Ketumo. It is also directed that the prison authorities would ensure that the health condition of the petitioner is looked into on a priority basis to ensure his well-being as far as his health is concerned. This would include both physical and mental condition. And the IO is also directed to file the latest status report, including the report of the doctor in this regard, on the next Netflix.
Obla, Your Lordship.
Item number 3.
Please, Lordship, this was an appeal against the conviction under 376. On the last occasion, Lordship, a query fell from your Lordships as to whether the
So, Mr. Sen, you were saying you will
My
withdraw
lord,
this.
so both item number 5 and 6.
First,
Item number 5 is an election matter.
5 you will withdraw it.
Lordship, with liberty to approach the election tribunal.
6 has become infructuous.
Yes, my lord. It's become infructuous.
Heard Mr. Sen, counsel for the petitioners was submitted that this petition will be allowed to be withdrawn.
It's under. I apologize for the. It's under the rules, the concerned rules. The time period for preferring an election petition is 30 days. This is one precedent where, my lords, Justice, thank you, was pleased to grant the opportunity to file an application for condonation with a further direction that be considered leniently.
My lord, I have
A
objection.
similar observation may be made, my lord.
My lord, I have objection to that, my lord, because if they are withdrawing it, they will file whatever application they
No, which is
request
why
to file before
I'm
the
withdrawing, because
before the
I've
election
spent enough
commission.
time here, my lords. And if I file an application, my application will be time barred. Similar situation was present.
Mr. Sen,
My lord,
if you have spent enough time here,
my lord.
whose fault is it?
No, my lords. I'll explain, my lords, why this has happened. This was combined with a different cause of action. That cause of action has some substance in item number 6 as well. Because that has come to an end, that cause of action has terminated itself. Now there's nothing left as far as that cause of action is concerned. Now what I am left with is the election challenge. That I have to go back to the tribunal. So which is why, my lords, it's not really any fault of my own.
Anyway, let the tribunal decide on
Yes,
your,
ma'am. The
application.
same observation that was granted here.
Yeah, if if you have to apply for condonation of delay and
My lord.
etc., that will
Yes,
be
lord.
looked into.
Kindly see para 6, my lord.
Heard Mr. Sen, counsel for the petitioner. Well, only 2 minutes. We are allowed to be withdrawn. However, I have withdrawn. However, the learned counsel has submitted that the petitioner would seek liberty to prefer a related application before another forum, that is the, what do you call it, election tribunal,
election tribunal.
Election tribunal.
for the election tribunal of the KHADC. Given the time that this petition given the period that this petition is under consideration before this court, there would occur a statutory delay in filing such election petition, election appeal.
No, my lords. Election petition.
Election petition. It is therefore submitted that this court would direct the concerned authority, election authority, to election tribunal to consider to favorably consider the application for condonation of delay. In this regard, the observation made by this court in the case of James Yangrai and others versus KHADC, I fully ignore, reported in 2022 SCC Online, back 652 at para 6, is referred to by the learned counsel. Mr. Elkriam, the counsel for the European for
The respondent number 7, Sima Pillai.
for the respondent number 7, to not objecting to the prayer for withdrawal of this petition, has strongly objected to any direction to be issued by this court as far as the said condonation of delay is concerned. Yes, Miss, anything? This court has considered the submission made by the parties. As far as the first part, as far as the prayer made in the first part is concerned, the same is allowed. This petition is accordingly disposed of on withdrawal. As to the latter part of the prayer made, considering the fact that this matter has been was pending for quite some time before this court, and also on perusal of the reference made by the legal counsel for the petitioner in the as far as to the judgment of this court in James Yagrai and others, Supra, this court would allow the prayer made thus, and would also, and in the same vein, would direct the election tribunal to consider the petition made by the petitioner, application for condonation of delay made by the petitioner, on consideration of the same.
As per law, my lord.
As per what?
My lord, so just add that observation, liberal approach, my lord. Only that.
That is, I have, you see,
Lordship, lordship.
I have concurred with what this supposed coordinate bench has.
Lordship, lordship.
You can, or would that be too complicated for the election tribunal to comprehend?
I'm grateful, my lord.
I think the liberal approach.
Item 6 has become infructuous.
6 has become infructuous, my lord, because contesting respondent has expired. It placed this to your lordship's knowledge last year. That may be closed as infructuous, my lord.
Mr. SN and the counsel for the petitioner has submitted that this matter may be disposed of as the same has become infructuous. Accordingly, petition disposed of as infructuous.
Highly obliged, my lord.
beg to mention item number 5. The matter may come up after 2 weeks, Lordship.
Not prepared.
Little bit refreshment is required, Lordship.
On brief made by Mr. S.D. Upadhyay, the Legal Aid Council, seeking accommodation, matter is adjourned. This is after 2 weeks. 10.
A similar prayer for item number 12, Lordship.
So, number 12. Same order.
Replay.
Item number.
Lordship, I beg to mention item number 3. Your Lordship, I'm praying for 3 weeks' time. Your Lordship.
But 3, you see, look at this.
Yes,
Look at
Your
the
Lordship.
case.
My senior is in
2021.
briefman, Your Lordship, that's fine.
Prayer is made on behalf of Mr. S.P. Mahanta, Leonard Senior Counsel. A prayer for adjournment is made on behalf of who is said to be in bereavement. Accordingly, prayer law. This is matter after
3 weeks, Your Lordship.
why 2 weeks?
2 weeks?
2 weeks, Your Lordship.
I guess time.
2 weeks. Appeal.
Hello, Lordship.
Please, Your Lordships, I beg to make a mention of item number 13, Lordship. Lordship, Mr. Paul is on bereavement. I'm praying this matter may be listed after 3 weeks. 13.
I do give more. I change everything.
Highly obliged. Your Lordship, I beg to mention item number 16, Your Lordship. It may be listed after 4 weeks.
You are appearing for?
Petitioner minor.
Appellant.
Appellant minor.
Appellant. Miss Leonard Counsel for the appellant has sought for accommodation on the ground that she is not prepared to be heard today. On premier, it seems allowed. This is matter after 2 weeks.
4 weeks.
4 weeks? Why? We'll post it after 2 weeks and see if you are not prepared by then.
Minor.
2 weeks.
Please, Lordship, I beg to mention this item number 4, Lordship. Lordship, we require some more time to prepare this matter, Lordship. At least 2 days' time, Lordship. This matter can come on Thursday, Lordship. Wednesday, Thursday, and subject to your Lordship convenience.
We'll list it after a week then. Excuse me.
After a week. Lordship,
Or premier by the appellant. This is matter after 1 week.
similar prayer for item number 10, Lordship. Lordship, this matter we're appearing for the first time today, Lordship. We're the newly engaged counsel, Lordship. This matter. So, I'm praying, Lordship, if this matter can be listed in a separate date, Lordship, not on the same date with this other.
2 weeks then.
2 weeks.
On premier by the counsel appellant. This is matter after 2 weeks.
Of life, Lordship.
May it please your Lordship. Your Lordship, I beg to mention item number 8 and 9, Your Lordship. Your Lordship, the conducting counsel, Ms. N.G. Shala, is indisposed, Your Lordship.
Otherwise, I'm prepared for a week. 1 week is okay, alright.
Accommodation is sought for on behalf of the Leonard, Ms. N.G. Shala, Leonard Senior GA, who is said to be indisposed. The same not be objected to by Mr. Leonard Counsel for the petitioner or Leonard Counsel for the appellant. Matter is adjourned. This is after 1 week.
Much obliged, Lordship.
That's 8 and 9. 8 and 9.
8 and 9 are connected matters.
Daily list, item number 1.
My lord, waiting for just 1 week, my lord, for paper book one. It's almost ready.
Mr. KSH, Northern Learned Counsel for the appellant, has sought for some more time to file the paperwork pre-allowed. This is matter after 2 weeks.
Item number 2.
Condonation. Come. My lord, there is an application for condonation of delay in filing the appeal, my lord. 411 days delay, my lord.
POXO case.
POXO, my lord. A legal aid matter.
You are legal aid.
Appellate, legal aid, my lord.
Mr. Khan?
Leave it to discussion of the court. It's a POXO matter.
Mr. M. Sharma, Learned Legal Aid Counsel, has submitted that this application, that the should be applicant, not appellant. Why you?
Applicant, apologize, my lord.
The Learned Counsel, that the applicant had preferred an appeal before this court, a criminal appeal before this court, directed against the judgment and order dated 31/10/2023 passed by the Learned Special Judge POXO in Special POXO case number 18 of 2020. However, a delay of how many days?
411, 411, my lord.
Has occurred while preferring this appeal. The ground being that what is the ground?
My lord, we received the we received the case record in 2023, my lord, and thereafter we did not receive the complete records, my lord. We wrote back.
So you see,
Receiving
the ground should not be your ground. It should be the appellant's ground.
Appellant's ground, my lord.
Why has he delayed in preferring his appeal?
My lord, since it was a legal aid matter, my lord, we received the
legal aid matter.
Legal aid matter, my lord.
It's up to you to explain to the court why. Maybe he has not been informed of his right to be here to file an appeal.
Partly that, my lord.
Or maybe because he feel comfortable in jail, or maybe
No, my lord. Partly he was not aware of his right to appeal, my lord.
You should say that. Learned Legal Aid Counsel. Ground being that the applicant came to know of his right to appeal against his conviction only through the medium of legal awareness, which was conducted in the present premises, and has now preferred the said appeal through legal aid. Hence the delay. Mr. Khan, Learned PP, in all fairness, has chosen not to oppose the application on the ground that the merits of the appeal is required to be heard and decided by this court. On consideration of the submission made, this court is convinced, this court is persuaded to allow the pre-admit. The delay in filing of the related appeal is hereby condoned. Petition disposed of. Registry to diarize the related appeal and list the same for admission after 1 week.
Deeply obliged.
Item number 6.
Okay, you be there. You know, keep it. You be there. No problem. None there. After
None
2
appears
weeks.
for the appellant. Oh, you see, what happened is, I think I made some comments on this also. These matters, were earlier listed, and soon after that they had gone undetailed. So we had listed, these bunch
Just to
of
streamline back again.
so as to
Absolutely.
get back into the mold. So we'll not make any negative comments
Okay. No.
on prayer made by the Leonard PP. List this matter for hearing after 2 weeks.
Much.
Item number 7.
Same.
Same.
Jo, harama.
Item number 11.
Please, Your Lordship, this matter has come up after a very long time. Last time was in the month of September, so I would need some time. Short notice, Your Lordship.
On prayer made by Mr. S. Marpan, Leonard Counsel for the appeal, seeking accommodation on grounds of personal difficulty. Matter is adjourned. This is now after
3 weeks, Your Lordship.
3 weeks.
Pleasure.
Item number 14.
Ready for you start your
This matter has been heard.
Your Lordship, no.
we would like to request the parties to be diligent. Like, time and again we have said, it involves the liberty of a person. So, if at all, the convict deserves justice or liberty for that matter, we have to give it to him. The sooner the better.
Absolutely.
Because
We'll start seeing
asking for a genuine here and there. Of course, genuine cases we will allow.
Absolutely.
But not only asking.
Yes, in my case also, he's been custody for 1.5 years, Your Lordship, in jail.
If no case is made out, then he will be there for another 20 years.
But he's a juvenile. I'll prove it.